it or video it and put it up on YouTube as well. My name is Matt Caddo. I'm the Senior Fellow in Public Policy with the American Kratom Association. This webinar really is going to focus on some specific state activities that are going on related to kratom. But I wanted before that to kind of give everyone sort of a general landscape of where we are, both at the federal and the state level. Obviously, in the July 29th, 2025 press conference brought needed attention to the 7-hydroxymitragynine or 7-OH issue. It obviously was intended by the Department of Health and Human Services Secretary Robert F. Kennedy Jr. and FDA Commissioner Marty McCary to the 7-OH issue, which they have determined is an existential threat to the safety and health of the American people. And they laid out their case for it. And unfortunately, because of a news media that even during the press conference that was held had a hard time grasping the difference between natural kratom leaf products and 7-OH. And that confusion is carried over into numerous outlets. And I've got to tell you that Commissioner McCary did a magnificent job in not only explaining it at the press conference, but he also went on multiple media outlets, national media outlets, in order to actually clarify why the FDA was focused on 7-OH and not natural kratom leaf products. And that confusion has found its way into a number of the state actions that we're going to discuss tonight. And I think it's one of the challenges that we have in order to educate both public health officials and policymakers at the state and local levels about what these differences are, why the FDA has chosen to take the action that they have based on the evidence and data they have available to them, and why it is critically important that that distinction between the two is transformed into public policies that make sense. There's the lazy way out, which is to say, well, we can't tell the difference between them, so why not just ban them all? And of course, that is a false premise. It's one that has not been the foundation for public policy, particularly with scheduling issues in other substances, because obviously, if you take a substance that is somehow adulterated or chemically manipulated, as 7-OH has done, from the original product, you don't ban them all. And I think the most famous example of an adulteration that was deliberately done was in the Tylenol scandal in Chicago, where there were a number of people who died. And instead of banning Tylenol, the obvious solution was to find how the proper reaction from a public policy standpoint would be. And in that particular case, it was to strengthen the packaging requirements around Tylenol so that, and other products that are sold over the counter, so they could not be easily adulterated by a nefarious individual who decided that they want to use that product platform as a way to kill people or to injure them going forward. So these are tough issues, but they're ones that cannot be. We can't get sucked into this idea that we ban kratom products because there are bad actors out there who are adulterating those products currently using chemical formulations and manipulations, which are obviously illegal and should not be allowed to be used. The DEA is currently evaluating the recommendation that has been made by HHS and FDA for the scheduling of 7-OH. The evidence and data is published on the FDA and 7-OH website. It is clear in terms of the evidentiary basis for doing so. Clearly, the only challenge that's left is how do you take the reality in the 7-OH space where there are bad actors who are going already have started because of the threat of a ban, have already started creating the next level of 7-OH products requiring a higher level of chemical manipulation, which are pseudodoxal products that are infinitely more potent. And then some people are actually creating what is clearly a lab manufactured product called MGM 15 and 16. And those products are currently being sold in the state of Florida. I hear the advocates for 7-OH say, oh, this just isn't the accurate representation about what our marketplace is like. We don't want those products on the marketplace. But I remember standing on the stage at the Champ Show in Las Vegas back in July of last year in a debate with Jeff Smith from Hart, where he defended the industry by saying, when I made the point that there were product formulations being made by the 7-OH community that were clearly attractive to children, including the manufacture of ice cream confection cones, which have no other a marketplace other than children. And he definitively stated on the stage there, and I will also point out that the moderator for Hart in that debate was Michelle Ross, who's a big advocate now for the Seven Hope Alliance group, another group that's advocating for 7-OH. And he said definitively that they had removed those products from the marketplace and they were no longer being sold. Yet, just a few steps away on the floor of the Champ Show, I walked out right after the debate and identified 4 or 5 manufacturers or exhibitors who were selling those 7-OH confection ice cream cones. Now, when we pointed out that the product formulations that are being used in the 7-OH marketplace today, which includes these sublingual and fast dissolving capsules in the form of chewable tablet, not capsules, tablets. And now they're saying, oh, well, they're not selling those anymore. Those are films and they're not selling them. You can buy them today on the internet. This defense of the false defense of trying to say, oh, we're not doing that anymore simply doesn't hold muster. But the critical point, which they continue to refuse to answer, is why. And I think there are two fundamental questions. One is, what basis, what evidence and data did the 7-OH industry have prior to market entry in order to justify the reasonable basis for safety of their products under the conditions of use? They have not been able to answer that question. And in fact, it was the chief science officer for the Heart Organization who participated in a leadership summit that we organized at the American Kratom Association in January of 2025, when he was asked the question, was there the required scientific evidence in September of 2023 when the 7-OH products were put onto the market? And his answer was no. They didn't, that science didn't exist. In January of 2025, a year and a half or more after the entry of those products, he said they still didn't have the required science in order to comply with federal law, but they were hoping to have it by mid 2025 and certainly into 2026. That is not the way the federal law operates with respect to these kinds of products entering the marketplace. And the threshold issue is whether they have the required science in order to do it. And clearly, their own science officers indicate that they did not. Now, when I ask these questions, and I've done so repeatedly on various forums, including with Miss Ross, who, by the way, gets angry with me because she wants to be called Dr. Ross, I respect that when a legitimate scientist has a different kind of opinion, but this isn't about a independent scientist now making an evaluation of some scientific research that's been done. Ms. Ross is a paid advocate for the Seven Hope Alliance and is no longer just expressing or interpreting scientific data. She is an advocate for them. And that, of course, requires that she be appropriately titled along the way. And I know she gets frustrated with it. She calls me a misogynist. No, it's about whether or not there's credible evidence that's available to us in order to make these kinds of decisions. And the second question that they're obviously not answering is, why is it that virtually every one of the 7-OH products that are on the marketplace today in their marketing material tout how these are going to provide therapeutic benefits in the form of pain relief and a number of other therapeutic benefits from the consumption of 7-OH products? At the American Kratom Association, we have reported more than 100 kratom manufacturers who have made illegal therapeutic claims on those kratom products because we believe that the integrity to the law needs to be maintained. And in fact, those companies have been reported, and the 7-OH companies are on the same boat. If you can't go to a 7-OH manufacturer and not see that they're claiming these therapeutic claims, which are illegal under federal law unless you have submitted the required data that would justify an approval under the new drug application process, or at a minimum, if you're using a structure function claim, which is allowable under the Dietary Supplement Health and Education Act, then you certainly have to go through the new dietary ingredient notification process. Just hasn't happened. There's some entitlement that the 7OH people believe that they have along the way. So that's the challenge that we're facing now with an industry that seems hell bent in order to maintain their presence in the marketplace without any adherence to federal laws along the way. And they justify what they're doing as saying, well, you've all heard the arguments, well, we're the same as Kratom, which is complete and total nonsense because we know that Kratom is a natural plant. And there is no way that they can make the argument, although they attempt to do so. And I understand why they want to do it. They say they're the same. In fact, they go to the ridiculous claims that the eight factor analyses that was done by Jack Henningfield originally in 2016 and then updated in 2021 and 22, they claim that Dr. Henningfield's work says that 7OH is not schedulable. The 2016 and 2021 eight factor analysis evaluated the trace amounts of 7OH that are in the kratom plant material that is after it's dried and shipped and sent to the United States. They were not talking about chemically reformulated or manipulated 7OH material, which flips the content of the product to make it a majority 7OH rather than a majority metrogenine. And it makes metrogenine in a 7OH product a trace amount as opposed to just the opposite with a legitimate natural leaf kratom products. The FDA has made that distinction. HHS has made that distinction. And I think you'll see shortly the DEA will make that distinction. But the 7OH people are desperate in order to try to attach themselves to a legitimate scientific article, when in fact it does not apply because it is in 2023, in September of 23, that 7OH products entered the marketplace. And now there is an eight factor analysis that's been done and updated by Dr. Henningfield that was submitted to the DEA, which you don't hear anything about from the 7OH people. And it concludes that 7OH products should not be allowed on the marketplace, given the current chemical composition and the obviously the eight factors in terms of their full evaluation along the way. So they like to borrow from the science that's been done without having a credible basis in order to do it. But let's make no mistake, the anti-kratom lobby, and they sometimes will expand that to 7OH, are doing what they consider to be the God's work in order to stop kratom from being sold in the United States and banning of kratom completely. And they are trying to attach themselves, and I'm talking about the Kratom Danger Awareness and other groups like that. Back in mid-December, the KDA people, and there's a fellow who is one of their advocates. He calls himself on X.com, Kratom Dad. I challenged him to a debate. I think that the most reasonable way for us to have a healthy exchange of ideas without sitting behind a keyboard and being a keyboard warrior is to have a discussion, make it public, expose it to the challenge of having to say it out loud and to engage in a debate back and forth with one another. Initially, Kratom Dad agreed. And then, after consultation with he and Wendy and another father of a person who believes that their child died of kratom, they decided that a debate was not a good idea unless, and this was an important caveat, they gave me 10 conditions that required me to adhere to and to agree to before we could have a debate. Now, I thought that was really interesting because, in my opinion, a free exchange of ideas isn't really about setting conditions on a debate that are simply unfair. But in this particular case, they had these specific recommendations. For example, they wanted me to admit in going in on this that, in fact, I knew that there are no such things as I would agree that there are kratom alone deaths. I have not seen any evidence or data to support a claim that there are kratom alone deaths. It's possible. And maybe, but so far it hasn't been proven based on the evidence that's been publicly available. And that's why I argued that these kinds of discussions are important, and we certainly could have an open and free debate about whether any of that is true. Unfortunately, they weren't really interested in having that discussion along the way. Secondly, they said that I had to acknowledge that the presence of other substances in kratom-related fatalities does not negate kratom's role as a contributing factor, and those cases cannot be dismissed. I partially agree with that. It doesn't negate that possibility that maybe there are some kratom related fatalities where maybe itself was the cause of the death, but there's been no science to document that, and there haven't been any studies to show that kratom itself interacts with some other consumed substance to cause a debate. I offered to debate the issue because that is an important one, and of course, I failed to meet that condition along the way. They also required that I had to acknowledge that deadly interactions between kratom and prescription or over the counter medications or people with medical conditions all represent deaths that can and should have been prevented. Well, that requires that you assume that kratom was the catalyst with those other kinds of substances or the underlying health condition, which then precipitated a pathway to a death. It's simply not true. There is some known evidence that there are drug to drug interactions, there are drug to supplement interactions. That's why the FDA has their FDA adverse event reporting system database to serve as an early warning for those kinds of interactions. And when those interactions are reported, the FDA observes a cluster of adverse events associated with two substances, and let's assume, for the sake of argument, kratom and some other prescription medication, they would then take action. That would require them to look at the controlled substance, which in this case is the prescription medication, controlled in the sense of regulated, and they would then require that a black box warning be put on that prescription medication that says you cannot consume this product with kratom. There's not been a single product where that requirement has been imposed because the FDA has looked at all of the so-called kratom deaths and has not seen the cluster of adverse events associated with kratom and that particular substance. So you just have to look at what the FDA has done. It's not what the AKA has done. It is not anything that we have contributed to. It is not our speculation. It is not our theory. It is, in fact, what the FDA has done along the way. Fourthly, I had to acknowledge the KDA is a volunteer-led Facebook group comprised primarily of family members who've lost loved ones to mitragynine toxicity. Uh, I will take them at their word at that. I have no way of verifying the claim. What I do know is that there was an offer and a statement made by Matt Wetherington, a trial lawyer, that he was going to fund the KDA with a significant amount of money in the millions. Um, and so the fifth requirement they had was that the AK acknowledges that it was wrong to characterize the Kratom Danger Awareness as an organization puppeted by outsiders and funded with dark money, their words, and doing so just increases hostility towards us as grieving families. Let me tell you something first. I have great empathy for any family who's lost a loved one. I know every family has suffered a loss, or you know someone who suffered a loss, and you can understand how that is obviously a deeply personal and an emotional event in your family lives. But there's a difference when you become a formal advocacy organization and you are not entitled to some protection or sympathy when you become that advocate that pushes a narrative which is grounded in information that you may believe and may wholeheartedly embrace, but it is not grounded in the science. And then when you are challenged, you cannot retreat back and say, "Oh, you're attacking grieving families." No, we're attacking the message, which is not grounded in any evidence and data along the way. But in this particular case, they're talking about the information that was obtained publicly, where a trial attorney offered to fund millions of dollars into this. And so please blame my lying eyes and ears about the support for the KDA from child lawyers. Certainly, they can provide the statement that any claim made by the KDA social media platform and call that trial attorney a liar for having said it, but don't come and blame us because we take it at face value along the way. Um, the sixth thing that they said that as a newly formed nonprofit, the KDA, with approximately $240 in donations to date, the KDA's resources are minuscule compared to the multi-billion dollar kratom industry and the billions of dollars invested in kratom advocacy efforts. If we're in the game of trying to suppress free speech and saying to companies or to individual consumers and advocates that we can't speak and that we can't fund these advocacy efforts, then we're somehow barred from participating in the debate. It's silliness. And yet they want that to be a condition of having any debate with me because, of course, they want to be this, obviously the underdog. They want to be viewed as the victim along the way. I say stand up and let's have the discussion. Deny and show with evidence on your documents that you're not getting funded by these trial attorneys, and then we could have that discussion further. Seventh, they say that medical examiners are trained forensic experts, and although no system is infallible, interesting caveat, the consistent identification as kratom as a causal factor in thousands of fatal cases across jurisdictions is not a vast conspiracy to falsely blame kratom. Well, I would correct them, and it's an important correction along the way. There are not thousands of fatal cases that are concluding that kratom was the cause of death. There may be hundreds of cases that are attributable to kratom being a part of the toxicology screen where it's detected in the bloodstream, but there are not thousands of cases where the kratom is viewed as the causal factor in a fatality. I'll give you an example of how this really goes off the rails. You know about the mother in Ohio where the coroners determined that it was a kratom cause fatality, and we sued them, and in the end, it came out that the coroners had to adjust the cause of death, admitting that in fact that the information and data that they had initially relied upon was insufficient to draw that conclusion, and in fact they changed the cause of death to undetermined based on their review of new literature that wasn't all that new, by the way, that was available to them. They simply chose not to look at it, but it's become the cause du jour for some medical professionals to blame kratom. No better example than what happened in the middle school in Georgia, where the report was given by the school administration that they had 5 middle schoolers who were hospitalized because of ingesting a kratom product. And there was a criminal investigation that was opened by the sheriff. We called the sheriff and said, are you willing to allow the substance to be tested by an independent laboratory, which he was willing to do? And when that test was done for 116 illicit substances to determine what the cause of these so-called hospitalizations were, they found nothing. And do you know what that substance was? It was this. It was dots, candy dots that you can buy in any grocery store or convenience store around America. This is what, at least what the parents and the children were claiming caused these hospitalizations. And all of this, all of the attraction to kratom came when an emergency room doctor, a trained medical professional, allegedly tested the products, which obviously proved not to be true, and concluded and told the parents that this was a kratom product, or likely a kratom product, that caused these hospitalizations. It simply wasn't true. And yet it feeds this hysteria, and it certainly goes to the anti-kratom advocacy community as a validator for proving once again that kratom was the culprit in something. And when testing is done, and this is the important point, when testing is done, it proves not to be true. That was true when the Centers for Disease Control did their survey of kratom-associated deaths. And of those 92 kratom-associated deaths, where the coroners and medical examiners reported that it was a kratom-associated death, they looked at it, and the CDC confirmed that it was only 7 of the 92 that were kratom only by the description and report of the coroner or medical examiner. When the CDC asked for the blood samples so that they could independently test them. They were able to obtain four of the seven. There are three blood samples that weren't available because they hadn't drawn a sufficient amount of blood. And what the conclusion by the CDC was, of the four, all four of them, they found were in fact polydrug use using more sophisticated technology. But all of the so-called kratom-associated deaths are part of the database relied upon by the anti-kratom advocates, and they do not want to be accountable for what the science actually shows. They do not want to be accountable for what the actual data and evidence is in supporting their claim that somehow kratom is the singular cause of a kratom death. And that's why we've said from day one that as we have examined every autopsy report that we're permitted to get our hands on, that we've been able to identify that in fact what was believed to be, for whatever circumstance, to be a kratom death turns out to be, as the FDA and as the National Institutes on Drug Abuse have both concluded, that kratom deaths are rare, but when they do occur, they're because of polydrug use or adulterated kratom products. And you see reports that are widely circulated now that there's X number of deaths, increased deaths in kratom in the last 2 years. Well, guess what happened within the last 2 years? There's 7-OH. And is there testing that's available for 7-OH to determine whether or not kratom actually, or in this case, 7-OH caused the death? And the answer to that is unfortunately no, because the 7-OH washes out of your bloodstream very quickly. And when they test it in an autopsy, all they see are trace amounts of metrogeny that are in every 7-OH product, except for the MGM 14s and 15s. So there you have the conundrum that's there. But every parent needs to have available to them the truth, not some hyped up anti-kratom crusade that's empowering them to become a part of this group, but rather to learn the truth about what caused the death of that loved one. And I remember that mother in Ohio said, I wish that more families would challenge what is being told to them by a medical examiner and coroner. And I think that's where we really are. So, do we think that medical examiners and trained forensic experts are deliberately lying? Of course not. Do we think that they use shoddy procedures? Do we think that they fail to follow the requirements that are published by the various organizations that they are members to and that provide postmortem investigation standards? Yeah, I think they are pretty shoddy because they've demonstrated that to be the case. Are they like that emergency room doctor that jumped to some conclusion because he heard that kratom use was increasing? Is it because he had a bias? We don't know, but it's certainly something we'd like to find out along the way. But bottom line is that for the KDA to suggest that, I have to acknowledge that medical examiners are trained experts and therefore, despite some potential for there be some infallibility, the consistent identification of kratom as a causal factor in thousands of fatal cases is not a vast conspiracy to falsely blame kratom. I think it's part of a misinformation narrative that's been generated by medical professionals over the past couple of years, and that's why we're in the situation that we're in today. Number 8, as the conditions, we're getting down to the last three. The AK acknowledges that many kratom distributors, manufacturers, and vendors operate with opaque corporate structures and shell companies, which actually makes it impossible for many families to pursue lawsuits. That is a talking point directly from the trial attorneys that are working with them. In fact, it is well understood that in the manufacture and distribution and the retail sales of kratom products, as there are for every product that's in the marketplace, there can be various entities that are established that are separate corporate structures based on product liability concerns and for what their responsibilities are. And just as an example, in the state of Georgia, the trial attorneys were the main advocates for a provision that requires in the state of Georgia, if you sell a kratom product, that you have to have a separate corporate entity description of a business operating in the state of Georgia, which requires you to create a new corporate entity. So it's almost a self-serving, self-feeding kind of growth in that sort of thing. Are there companies that have attempted to avoid responsibility? That happens. And when that happens, they certainly should be held accountable in the appropriate venue, which is a court of law. but don't use it as an excuse because the trial attorneys don't like it as a basis for claiming that kratom deaths are rampant, when in fact that doesn't support that notion at all. Number nine, while some KD members are involved in individual product liability cases, most are not, and the civil court system is a legitimate mechanism for resolving disputes. Of course, the court system is a legitimate mechanism for resolving disputes, but I can tell you that there are many cases, and I've seen them firsthand, that are not brought because they don't have the merit to them because it was not just kratom. It was in fact other issues, other substances that were involved, and that really speaks to that. Finally, and this is one that they characterize as last, and I quote, the AK acknowledges that the open quote, show me the autopsy report, close quote, culture promoted by the pro-kratom community is ghoulish and inappropriate. No, if a family wants to have a private situation and protect the privacy, they're entitled to do so. But they can't come out and say, we have our son or daughter or our spouse or a cousin or a family member died of kratom and not be willing to have that autopsy subjected to a review so that we know. Because it's not about us knowing, it's about policymakers who really have to make the decision and they should know. And so autopsies ought to be present and available and evaluated for what they are. We have a situation in Idaho where there is a case that's being circulated widely on Facebook claiming that a child died of a kratom overdose. And the facts of that autopsy are open to significant challenges. And we believe when the final evaluation is done, it's going to show that the medical examiner didn't do a very good job. And they leapt to this conclusion. And I can tell you about a case 5 years ago, where actually 6 years ago, where a coroner in the state of Idaho, I think it was Bannock County, called me and said that he had been jawboned by the FDA to call a death case a kratom overdose. And the circumstances around that case were that the individual had taken kratom because he was thinking that it would help him get off of some of the drugs that he was on, had gone to a bar in the dead of winter, had become intoxicated, stumbled out of the bar, fell into a ditch, and died of hypothermia. When they did the toxicology screen, they saw high levels of alcohol consumption and high levels of other drugs, and kratom was detected in the system. The FDA itself called this coroner and said to him, we want you to change the cause of death to kratom intoxication. Now, that was in 2019. That individual that was talking to me said, I am the coroner. And they told me that when I refused the FDA's request, they said, let us talk to the coroner. He goes, I am the coroner. And then they escalated it to the Association of Coroners in the state of Idaho. And he said, let me get her on the phone with us. And the FDA hung up. So this is what happens. Now, I'm glad that the FDA has now changed their posture. But back in 2019, they were riding that wave of anti-kratom narratives. And to go to that level, it's understandable why today we would still see remnants of that, where you have medical examiners and coroners who are leaping, or emergency room doctors who are leaping to incorrect conclusions about kratom. So I think the unfortunate part of this is that when you challenge an advocate, and I'm talking about advocates, not about grieving families because they're entitled to their privacy. We should show respect and empathy for them. But when they take it to the next level, organize and become advocates, then it's fair game for these discussions to take place. And they cannot hide behind, oh, well, you can't attack us. There is a very strong advocate in the state of Virginia who appears to be a well-meaning and very intelligent individual. His name is Dean Francis. You can go on LinkedIn and you can see he's launched a strong anti-kratom crusade. And he went after a kratom advocate and demonized her because she challenged some of the statements that were being made by a KDA advocate, an advocate, not a family member who was merely having private grieving, but rather it was an individual who was using that particular situation as part of the KDA advocacy. And yet Mr. Francis, obviously was unhappy about that. I asked Mr. Francis if he would have a public webinar where he could invite his scientists because he believes that his son became addicted to kratom, and it had very significant adverse effects on his son. I don't know the particulars of that case, only that that's what he represents. I understand it, and we could have that discussion. I don't know what the product was. I don't know what the concentration of the product was. At this point, it's still a mystery. But I asked Mr. Francis if he'd be willing to get his scientist, and he, on a webinar, I would invite a scientist on the kratom side, and we could see. And initially, he agreed. And then he said, no, on second thought, no, we don't want to do that. Not yet. Well, when's yet coming? Because he's involved heavily in campaigning in the state of Virginia in order to try to enact a kratom ban in the state of Virginia. Families who are grieving have every right to grieve. They can do so in private. They deserve our empathy, and no one in the kratom community should be attacking a family in that circumstance. But when, as I said earlier, you become an advocate, when you enter the public world of dialogue and you want to make your case and you want to say things and draw conclusions based on evidence and data, it's challengeable. And it is fair debate that should happen rather than hiding behind, the fact that you lost a loved one and not being willing to be accountable for it. The disinformation campaign against kratom is real. Coroners and medical examiners need to meet their own standards for postmortem investigations. ER doctors have become advocates rather than caregivers. Obviously, we've seen that happen. So I think that that's our challenge overall. So I want to talk to you now, and then we can open it up to answering some of the questions that you can post in the chat along the way, the question and answer section. But Ohio. The Ohio Board of Pharmacy, at the direction of Governor DeWine, did two things. One is that they emergency scheduled 70H. That was an emergency rule. It was put into effect, and in the state of Ohio, 70H is banned. They have a brief period in which it will become fully effective. They also opened up separately, under regular rulemaking, a proposal to ban metrogeny. Now, that process is ongoing right now. The Board of Pharmacy received a presentation from the chief pharmacist at the Board of Pharmacy on her eight-factor analysis. I listened to that presentation carefully. I can tell you that it was riddled with outdated science. And I know that the KDA people are all upset that I said that, but it's true. There was outdated information that they were relying upon that simply has been updated by science, by studies that have been done, and by new literature, which was not adequately, actually addressed by that chief pharmacist. I think that that's significant. We are going to provide a rebuttal to that eight-factor analysis because I think the conclusions were outdated, inaccurate, and I think that they were poorly framed in terms of taking this major action. But the thing that was most critical about that, after a detailed, complex presentation by a pharmacist, you had 8 members of the Board of Pharmacy appointed by the governor because of their expertise in these areas. And you would have thought that one of them would at least have a single question about the very technical, complex presentation made by the chief pharmacist at the Board of Pharmacy. Not a single question. Rapidly going to unanimously approving, moving forward the rule that had been requested by the governor in order to have metrogeny become, at the conclusion of the review process, a scheduled substance in the state of Idaho. I'm sorry, state of Ohio. That's something that obviously needs to be addressed, and we are going to do so. The first process in this step is that under Ohio's law, which is called the Common Sense Initiative, they are now soliciting comments that are due by January 28th. This is an evaluation of the economic impacts on the state of Utah, primarily on businesses who are in the business of retailing kratom products. If you're a kratom bar owner, if you are a kratom specific shop, or if you are a convenience store, all of this requires that there be a report to the state in order to allow the legislature to make a decision about whether the adverse economic impacts on the state outweigh whatever the arguments being made by the Board of Pharmacy about the alleged harms that kratom presents in the state of Ohio. When the Common Sense Initiative is concluded, then the Board of Pharmacy will open up a general uh, comment period and a hearing, we believe, for metrogeny being scheduled. When they did this 3 years ago, we had over 300 kratom consumers who showed up, and it was after about 200 of them had testified, the Board of Pharmacy waved the white flag and said that they were not going to proceed. And I think that that's where they need to be this time. We need to replicate that. And obviously, we will be encouraging every kratom consumer. And here's why you should do it. I suppose there are some kratom consumers sitting at home saying, well, it's not that big a deal to me. I know we're going to win. We've won in the past. The KDA is actively putting out information onto social media saying that they are working with the governor's office. Let me repeat that. They are working with the governor's office, and the governor's office wants us, the KDA, to submit comments in order to make sure that the Board of Pharmacy concludes that metrogeny should be a scheduled substance. I do not begrudge advocacy. They can do that. But make no mistake that they are gearing up with their 400 and some dollars that they've supposedly raised, and they are actively pursuing a ban on kratom in the state of Ohio. And we need to rise up, fight, and be prepared to handle that kind of thing. That hearing, we will need to be well populated with kratom advocates to tell the true story, not the story that was told by the chief pharmacist by the Board of Pharmacy, which was heavily tainted and didn't adequately review the truth of the matter, in our opinion. We need to stand up and have that message told. When that hearing is concluded, then it is up to the Joint Committee on Agency Regulatory Review, I believe is the name of the JCAR committee in the legislature, who will then themselves have a hearing, and we will want to make sure that we obviously have our teams there, our advocates there, and the experts there that will tell the true story about kratom and its safety profile along the way. I will mention to you that the chief pharmacist did not give any credence to the FDA's dose finding study, which directly contradicted most of what she was saying about the potential hazards of kratom consumption. And that's an interesting point because the FDA certainly took notice of it, and they have now shifted. And it's Commissioner McCary who has said that the focus of the FDA is not on natural kratom leaf products. So, what is it at the end of the day that the Board of Pharmacy chief pharmacist knows about the safety profile of kratom that the FDA doesn't? Because if she were right, the FDA would be advocating for metrogeny to be scheduled just as they have for 7-OH. They would not have said that natural kratom leaf products are not our focus, because it is the FDA's mission and mandate to protect the health and safety of the American people. So what is it that she knows? And what is it, as she presented that material to the Board of Pharmacy, that she knows that the 12 independent experts, called the Expert Committee on Drug Dependence, that were responding to a recommendation for scheduling of kratom at the international level with a much lower threshold for evidence and data than the 8-factor analysis embedded in the Federal Controlled Substances Act and in the Ohio law. And yet that expert committee on drug dependence unanimously agreed that kratom didn't need to be scheduled. So what is it that they know? And of course, the answer to that is there isn't anything, that this is just a misapplication of an amalgamation of a lot of information that is simply part of this disinformation campaign about kratom that's a carryover and is now outdated along the way. So we have a challenge in Ohio. We have a window of about 60 to 75 days that we are going to have to be very active in fighting back against this misinformation campaign that is being launched there. And then there's a bigger issue, and that's as much as I can tell you about Ohio. And again, I'll come back to any questions anyone has. There are a number of states that are now following the guidance that's provided in the current language that's on the FDA and Kratom webpage, which we know is badly outdated and is inconsistent with Commissioner McCary's statement, where he said that the focus of the FDA is not on natural kratom leaf products. That site needs to be revised. It begs for revision in order to align itself with the commissioner statements and the conclusions the commissioners made based on the evidence and data that's available to them at the FDA right now. They're slow, and they've told us they're going to make revisions to that site. But currently, the language on that site, which empowers many states in order to use their food statutes that overlay with the federal Food, Drug, and Cosmetic Act, you're seeing California, a major marketplace where the California Department of Public Health is relying almost solely on the FDA and Kratom website. That's why that website needs to be up, web page needs to be updated along the way. It is when you look at all of the bases for the seizures that are being taken in the state of California, it is because of the FDA and Kratom web page. And in some cases, the inspectors are actually delivering a Xerox copy of the FDA and Kratom webpage as a justification for it. So we're working hard with the Department of Public Health. We're working hard with the legislature in order to push along the Baines bill, which is the Kratom Consumer Protection Act. There is also a bill that's been filed for to ban 7-OH, and the 7-OH advocates are coming out of the woodwork saying, "Oh, Kratom and 7-OH are the same." We know that's not true. They're saying that to the Kratom advocates, hey, mark our words that if they ban us, the next amendment's going to be to ban all kratom. Well, that's the same sucker job they did on us to the kratom community in September of 2023 when they entered the marketplace and called 7-OH products a chemically manipulated, horribly potent product, kratom. And that's why we have to resist this kind of enticing deal that we have to join the 7-OH people in opposing Senator Umbrecht's bill. We're not going to do that. We think that good sense is going to prevail there in California, and we think it's a good demarcation that needs to be done. The same replicable situation is occurring in Minnesota, where the Department of Agriculture is relying upon the FDA and Kratom webpage and the language in it and why it has to be corrected. And we're working hard there. We also are working with a member of the legislature that actually starts up in February for a Kratom Consumer Protection Act. We're seeing the same thing in Michigan. We have a Kratom Consumer Protection Act there, and obviously we're doing good work up there in working with the agency and the governor's office. But they're relying on the FDA and Kratom webpage. The same is true in New Mexico, and New Mexico has been more difficult because they're just locked and loaded that they're not going to believe anything that any of us say, and so they're relying on that, and so we have a lot of work to do. But the confusion that I referenced earlier, that was the direct result of what was happening in the FDA's press conference that they held on July 29th of last year, where they called for the scheduling of 7-OH. And now the conflation of the two substances, kratom and 7-OH, is leading to many legislators who simply haven't done their homework, haven't seen the evidence and data that's required, are proposing bans. We see it in New Jersey. By the way, New Jersey is an example. CJ's Law, named after a young man who died allegedly of kratom only. And yet the autopsy, which is publicly available, contradicts that directly. And so, as much sympathy as we have for the family, for the struggles that that young man had, it's not the basis for the enactment of legislation that doesn't support what that autopsy says. Certainly, regulations are important. We believe in them, and we think that there could be certainly tighter regulations than currently exist in New Jersey, where there are none. But that's vastly different than having a ban as been proposed. We all know that the ban in Connecticut is going through the rulemaking process, and we're working with the Connecticut legislature now to try to get an amendment in that draws the distinction between 7-OH and natural kratom leaf products, which we think the FDA is correct on as we go forward. Bans in South Carolina, where well-intentioned legislators simply have it wrong. That's true in South Dakota. It's true in Idaho, where we understand the Police Chiefs Association is going to advocate for a ban bill. We have a KCPA bill that addresses the issue of good regulatory framework to protect people, to make sure that it is safe kratom products and they're properly labeled in the works up there. So we think that's great. In Montana, the Board of Pharmacy is looking to ban 7-OH, and the 7-OH advocates came out and said, "Oh, kratom's the same as 7-OH," and of course that's created some confusion. So we're working up there too, but the FDA and kratom webpage is giving us trouble there. We have ban bills in Massachusetts, but also a KCPA bill. Massachusetts is an interesting state in that their legislative process is kind of difficult, but we continue to work there and we're pushing hard. In New York, we had good news with the governor signing bills that would limit the age limit to 21 and for labeling restrictions. And we're working with them on some specific contouring of that to make sure that it is something that actually allows for the sale of safe kratom products and bans the bad stuff. We expect that there will be a ban bill in Tennessee, but we are working now with legislators there to have them to advocate for the KCPA. We've seen ban bills being rumored or being talked about directly by specific sponsors in Iowa and Kansas and in West Virginia. So we've got work to do there as well, and we will obviously do that. And we've got a KCPA and a ban bill in Pennsylvania. So that's replicated in lots of other states. So we've got work to do. Obviously, we need the advocacy community. I can tell you that there are a number of other states that are doing it, and I'm glad to talk specifics. I'll tell you Florida, where we are there. There is a obviously a bill that was advanced by the Attorney General in order to codify the emergency rule he put in place on 7-OH, which restricted the content of any product to no greater than 700 milligrams, 700, I'm sorry, not milligrams, 700, 400 parts per million by dry weight. We believe that that is a standard that's not well understood by consumers. It ought to be based on the number of milligrams in a product, nanograms per milliliter, whatever the right standard is that is understandable by consumers. And we believe that that should be amended in the legislature. We're working on that along with our KCPA bill. This illustrates how complex these kinds of discussions can be. I was on the phone with the Arizona Attorney General's office, with the Missouri. I met with the Missouri Attorney General's office. I met with the Department of Agriculture in Georgia. We're working hard in order to correct the record, to give proper alignment, to give information that's credible to these various regulatory bodies so that we can, in fact, deal with the issues that are currently being thrust up there. So we have a national challenge that we all are working on, and we encourage every advocate to get re-engaged just like we did in 2016 when we beat the man. And the man being a disinformation campaign that had been initiated by career staff at the FDA that subsequently was proven, as Dr. Zawa, then the Assistant Secretary for Health in 2018, to characterize what the FDA people at the time were saying as embarrassingly poor evidence and data and a failure to consider the overall public health. We've made real progress since then, and we need to continue that progress as we go forward. So I think that's the bottom line in terms of what we're doing. I'm going to turn to the questions, and maybe I've answered some of them already, but I'll try to go through them quickly. I don't want to keep everybody all night on the phone here. Anthony asked, when is the new California legislation becoming active and officially going into effect? I want to know how much longer I have. Well, the legislative process is ongoing. The Baines bill passed the Assembly unanimously. It's now before the Senate. It's going to require some activity by the appropriate committees in the Senate. There was some realignment of committee chairmen that was done, and so we're waiting to see. The current ban bill on 7-OH is just starting, and we'll have hearings here, and so we'll have to see how that goes. Adam asked, how's the Facebook fight going? We have members of Congress reaching out to Meta and to YouTube, challenging them on the basis for their allowing 7-OH ads to be up there where they're making money, but not allowing advocates to participate in their First Amendment rights to advocate for obviously the positions that we take on ensuring that safe kratom products, natural kratom leaf products, are available to consumers. So we're working hard on that. Drea asked the same thing about California. I think that I've answered that. Stephen asks, is there a way to get the latest 8 factor from Dr. Henningfield in 2025? That one is on 70H, and we certainly could. I'll make sure that it gets posted on our website so that you can see it. Second is California AB 1088. That's a Baines bill. Having passed Assembly, still able to move in 26 in the Senate? Yes. It does not have to restart from scratch. It's already passed. There are there may be some amendments that would require then going back to the entire body, not starting the committee process again. But that's typical of these kinds of things, and so we'll just have to work through that. Um, Nicholas asked, any update on the appeal for Wisconsin? We're working hard in trying to negotiate this, slow moving. I hope to have a better update on this in our next Zoom call, but that one's frustrating for me because we know that the Controlled Substances Board has acknowledged that kratom doesn't meet the criteria, and now it's up to the legislature to do something, and so it's a very complex issue. Um, Misty asked, is the Florida case fee similar to what Colorado's was, where they're trying to stomp out mid and small size vendors with high fees? Uh, this is not as straightforward as I'd like it to be, but the fiscal note on the original KCPA that we were advocating for in the last couple of years uh, had a fiscal note from the Department of Agriculture that was astronomically high that put everybody out of business. And so we're that's gone, I think, for now. And now the Department of Agriculture just waiting for the legislature to give them more direction. So I think that we're okay in that. I'll keep you posted as we go along. Michael asked about what's the opinion on Illinois state level? Do they agree with the local bans, or they keep pursuing KCPA? They are going to continue to push the state KCPA. Whether or not we can get preemption on local bans is an up in the air thing. Most legislators don't like that in their local deal, but once we get the state KCPA, and I think it diffuses some of this state stuff, and that's where we are. Also, do you think that the idea to have it where kratom is not sold in gas stations but sold 21 plus establishments and require licensing and employees be trained in educating customers? Those are things we're discussing. Uh, Dr. Nora Volko from NIDA, I think, said it right when she was discussing how kratom should be sold in retail outlets where it's accessible, whatever level. And her argument was simply this, that there are many people who have accessed kratom because it helps them to alleviate their opioid addictions and withdrawal symptoms, and it helps them as a harm reduction tool. And her view is that many of those people will never seek treatment that they should get because of the stigma attached to it. She also said that there are many people that don't have access to a bed because they live in a rural location where the beds aren't available, or they live in a location where the beds are available, but they're too expensive in order to access. And so that bars them from getting there. And so her argument about gas stations is as long as the product is compliant with state law, as long as there's a good enforcement to make sure that you're not selling adulterated products, that they should be allowed to be sold. And I think that sort of mirrors what happens with alcohol and cigarettes. So it's a good argument. We remain hopeful that we're going to be able to get that done. Misty asked, when do we need to submit personal testimony? There will be a posting set up by the Board of Pharmacy that will follow the Common Sense Initiative when that concludes on January 28th. So we'll keep you posted on that. Nick asked, is LA Public Health still going after natural kratom? They absolutely are. They believe that the FDA and kratom webpage justifies their enforcement actions. That's why we're trying hard to get that done. Um, Adam makes the comment that it sounds like Governor DeWine wants a ban. Uh, he does. But it's also true that he, A, is not running for reelection, B, that it's typical of every governor in tension between the legislature and the governor, that he has not, doesn't have a deep reservoir of support in the legislature. So I think that there will be an open discussion that will be fairly held about kratom and whether or not the governor is right on this. And we know he's wrong on it. So that's the way it is. Jeff says, um, he adds the 2 cents on kratom testimony to all the links that have a place for them. Even though I'm from out of state, should I continue to do this or am I wasting my time? Uh, we One thing we don't want is people capturing the IDs or the zip codes of a resident in a state when you're not that resident. We simply tell people do not do that. We want this to be a credible advocacy opportunity. So you can comment and not be from that state, then that's fine. But don't misidentify yourself. But what Jeff has suggested is important. You should comment. There's nothing wrong with it. And the more people that are able to weigh in with their testimonials about Kratom, the better. I guarantee you that the Kratom danger awareness people are playing the game, and they are not going to be able to win this battle without their playing the game and being out of state. So let's do the same thing. If their voices are credible, ours are too. And you can't just slice and dice because you have someone who wants to exploit the situation. Um, Heidi asked us to update. I've already done California, Utah. Utah was the first state to pass a Kratom Consumer Protection Act. They have a state senator there now who, by his representation on a Facebook post, is representing a client in a product liability case. He also happens to be an influential state legislator. He has already made his presentation on a Kratom ban bill to an interim health committee in November. And I watched that committee hearing. I was surprised at the lack of research that this senator had provided. For example, during the presentation that he made for advocating for his ban bill on kratom, said that all of the research that's been done has been funded by industry. That's not true. The vast majority, the overwhelming majority, how do I say this? There are very few industry funded studies, over $100 million in NIDA funding of kratom research. But specifically, he was asked by a member of the committee, well, what about the FDA's dose finding study? And he said off the cuff, and I could accept that maybe he was just wrong. He said, no, that was an industry funded study. But at the end of the presentation, looking at his phone in order to give it some sort of credibility, he then announced, without being asked, he said, I verified. And he kind of looks at his phone like that's the verification. And he said, I verified that that was an industry funded study. It is not. If you go to the FDA and Kratom webpage today, it says that that was an FDA study, and they are now in the process of having it peer reviewed and published. So how he says that, I don't know. But I know he's an impassioned advocate. He told one of our lobbyists that I'm a liar. He said he can't talk to the AKA in part because I lie about things. And his lie that he identified was that I said that there are no deaths that are associated with kratom. That's not a lie. That's based on the evaluation of the material that's available. And if he would look at it objectively, and as an attorney, he certainly can, he would see that there are no kratom deaths that are kratom only that have been identified so far. There's interpretive data that you can make from various research, but there's nobody that claims that there is a actual kratom death. There are medical examiners and coroner's reports that say, that there are metrogeny intoxication. But when you look behind it, you see that it's not well documented. They didn't follow their own procedures for postmortem investigations and all that. Uh, then, then on a radio interview, this good senator said, without question, that the Mayo Clinic has done some really good research on kratom. Now, obviously, he's borrowing on the credibility of one of the finest medical institutions in America. But the truth is, the Mayo Clinic hasn't spent one single penny on kratom research. They have a multi-million-dollar information sharing agreement with the FDA, and they have republished statements made by the FDA, perhaps with some commentary of their own people, but it is a paid relationship, and it's not based on any independent science. And I think the senator was wrong on that. Now, do I call him a liar? No, I think he was misinformed. And I think there needs to be a more rational discussion along the way. Brian asks, what's the AK's position on the new Florida bills being proposed to have FDEX regulate kratom manufacturers under CFR 210 pharmaceuticals? No, we oppose that. And the bill will also legalize 7-OH. That's an advocacy for 7-OH. No. We know that there are identical bills in Missouri, but there's already been a KCPA passed in Missouri, vetoed by a former governor, and we think that we're in good terms there. Obviously, the bill in Florida was sponsored by Senator Gruters, who's a good friend, former advocate for KCPAs. But this new issue of 70H, he's suddenly gotten captured by them. So we think that there is a lot more advocacy work that needs to be done with Senator Gruters to help him understand why the 70H people are feeding him a bucket of malarkey, if I can say it that way. Brian, we're going to be working closely with you down there. Our lobbyists are on this. So we're working away. Now, a question from Ethan on California. Uh, AB 1088 is the main focus, not SB 758, although I support that bill as well. Now the state Senate is back in session. Is the health committee meeting? Are the committee members defined? Yes, we know who those people are. Our pro 1088 efforts being spent on focusing on our personal state senators. We're going to have an advocacy program that we ask you to look at in terms of who you should be contacting, what hearings you should try to attend. That will be an updated situation. We're now gathering more information about when the informational hearing is going to be held on Kratom. That's an important first step that was promised to us. And then we'll see where the committees go. Is the AK going to take the lead organizing communications? Yes, we are on top of it. We are partnering with the Global Kratom Coalition and the Botanics for Better Health and Wellness. We are in lockstep on this. Are there AKA lobbyists in Sacramento? There are, as there are for the other groups that I just mentioned. We will give you a clear and solid structure to follow in supporting the passage of 1088 going forward in the Senate. And obviously, the actions by the California Department of Public Health are hurting everyone, and we want to get you back in business as quickly as possible. Um, Denver asked, how can I get the location of the Ohio, I'm not sure, netting so I can show up? Oh, the meetings. We'll give you that information, and certainly you'll have adequate time as much as they give us. Sometimes these committee hearings get called very quickly. We'll do it. Rebecca asked, how do we fight back against the horrible headlines that state kratom when the article is about 7OH? We're focusing on this in a PR campaign with the media. We've already sent out a couple of media advisories about it. You're going to see, I think, some real progress on that front because obviously they're not doing it right. Christo asked, can you all figure out how to test for 7OH from autopsy so MIT stops getting blamed? This is a challenge, but when 7OH washes out of the bloodstream and therefore is not present in traditional testing, there are artifacts that are there. And so we're looking to try to identify testing methodologies that we will ask the medical examiners to follow. And I think that's important. Misty says we should go state by state and have our town hall meetings. Misty's doing a fabulous job along with her advocate friends in moving these information hearings or town halls forward. I'm glad to participate as much as my schedule allows in order to participate with those. So thank you for that. Eric asked, do you think Kansas City is still looking to ban kratom? I was there in Kansas City this past week and they didn't hold the hearing. They pushed it to the end of the month. I think they're going to separate kratom out of it. And I think you're going to see there be a clear distinction on those products. Ed asked, can persons outside of Ohio offer personal stories? Yes. It's up to the advocates, the legislators to determine who they listen to. Adam asked, does Florida KCPA require $3 million liability insurance policy? That's not something we advocate for. You can't get personal liability insurance in the kratom industry unless you go to extraordinary lengths. And we think that that's not a good policy, and we certainly don't push for that. Christo asked, what happened to SB 299 in Ohio asking for the KCPA? There's going to be more action on our KCPAs in Ohio, so stay tuned for that. Why are these two sisters blaming kratom for their brother committing suicide? The grieving families that feed into this disinformation campaign that want to go public with these claims, these are heart-wrenching stories, and we're gonna fight those. Misty points out in Tennessee that the main proponent for banning kratom is running for re-election. We had to vote her out. I don't disagree with that. I'm going to be in Tennessee on Tuesday to talk to some legislators, and hopefully we're going to get moving on that. Drea asked, what's going on in Rhode Island? Don't they have a KCPA and ban 7OH? Yes, they do. And there's nothing happening there other than 7OH people want to get rid of that provision. Ethan asks, I'm assuming that there is a vision for putting pressure on the California State Senate to move 1088 ahead. There is, and we're working hard to promote that bill to get it passed. We want to make sure that there's a clear message sent to the California Department of Health that kratom is legal for sale in the state of California. So we're going to push them as fast as we can to get this done. Crystal says, as you know, the KD is working with Andrew Kolodny anti-opiate movement, and he supports Suboxone, which is the opiate, because he works in that space. Absolutely. And you know, they're entitled to their argument, but that doesn't mean they get credibility as a result of it. So you know, they how they can make that connection and thinking that supporting someone like Kolodny, who's this big supporter of Suboxone for everything, makes no sense to me. So we're going to keep fighting on that. Um, Nick asked, is there an actual timeline on the FDA updating their webpage? No, we've gotten commitments from the commissioner's office that it's going to happen. We keep looking every day. It's a fight with the mid-level layer of career bureaucrats who just don't think it's a very good idea. So we have to kind of live with that. Shane asked, are there any large kratom advocacy groups that can join alliance with the AK in lobbying? There are. The Global Kratom Coalition and the Botanics for Better Health and Wellness are working together cooperatively. This is an alliance that we formed. We have vastly different backgrounds and issue positions. We have united going forward with working in these states. So I think that's a fabulous outcome, and we're working hard on it. Jennifer asked, what is the status of KCP in Ohio, or is it in legislation? The rulemaking process involves the legislature, but we also have a KCPA that's being fought there. Ethan says, not sorry to hound. I may not have been very clear, so don't worry, Ethan. You're not hounding me. Just hoping to clarify. Is there any sense of when the fight for 1088 will begin? This is determined first by an informational hearing, and then the Senate will take up 1088, and we're hopeful that we can get that pushed through. Adam asks, is there any update on the federal KCPA? We have the language that has been approved by Ledge Council. We're going to now working with the sponsors to get it actually introduced. You'll see that in the next couple of weeks. Ed asks, is harm reduction understood and or accepted by policymakers? Great question. Some do, but some in some sectors, harm reduction is a bad word because, particularly in some of the conservative states, they don't like to see the distribution of needles, which is a good harm reduction tool. They think that that's just empowering and enabling drug addicts. So it depends on the jurisdiction as to whether that argument works. More conservative states, I would say no. In the more leftist states or more liberal states, it does. So we keep working on that. So we've been at this for an hour and 45 minutes. I want to thank everyone for joining us. Misty makes a final point that the anti-kratom documentary is premiering soon. So get ready, advocates, no question. And by the way, I was interviewed for that particular documentary that's now being put out, highlighting the death of a family member that was close to a big Hollywood producer, which is why it's getting this treatment as being this high level, high quality production. But I can tell you that what's happened in the intervening 2 years doesn't allow for that documentary to be very accurate about anything. It'll be interesting to see if they account for the FDA's change in position. We'll see how it works out, but it's as in the same way that science evolves, in the same way that the policy landscape evolves. We hope that people will see this for what it is, and certainly recognize that for those grieving families that they feel very empowered in order to attack kratom, but they have to be accountable, and that's the bottom line for us. In the same way that when you challenge these people to a public webinar, they run for the hills. And that was true with the KDA dad. That was true with Mr. Francis in Virginia. These are probably wonderful people outside of this advocacy thing. I hope they think that I'm a reasonable person too, but I've been called a murderer. I've been called, a drug dealer, and that's sort of the reaction that comes from some of the extremists on that side of it. And we unfortunately have had some people on our side attack those people. That's uncalled for. Shouldn't happen. I hope we work together on this. So we will do exactly what we've described here. We're going to continue to work on it. We will hold some state-specific webinars. For example, in California, when we get a good view of when the scheduling for the informational hearing, which will be the trigger for 1088 to move through the Senate, it will go through one of the Senate committees, maybe two, depending on the appropriation required. You might have the Health Committee and the Appropriations Committee. Then it'll hit the floor. And then if there are any amendments, it'll have to go back for a full vote, not back through the committees in the California thing. So we'll continue to work on that. State-specific webinars in Ohio and California are likely, certainly in Utah as the legislative process there heats up, and in other states as we identify the need to do it. So my appreciation to everyone for stepping up in helping us, listening today, seeing where we are, and certainly we welcome your input. We need your help in these various states in order to be the advocates to tell the story, the testimonials, to counteract some of the misinformation, the deliberate disinformation that's being circulated by the anti-kratom advocates. So thanks to everyone. A special shout out to those influencers, Misty and her team that advocates for it. I know that we couldn't be as effective but for their efforts. And I encourage everyone to follow Misty and listen to her podcast along the way. So thanks, everyone. We appreciate your time today.